Welcome to Tax Problems Explained from the perspective of an attorney, a CPA, and a former IRS agent.
Welcome to Tax Problems Explained from the perspective of an attorney, a CPA, and a former IRS agent with Lawrence Ullmann. With decades of experience inside the IRS and private practice, Lawrence helps individuals and businesses understand how the tax system really works and how to resolve serious tax issues. I'm Leanne Lyon, and today we're talking about IRS appeals. Lawrence will explain what they are, how they work, and when pursuing one makes sense. Hello, Lawrence.
Hi, Leanne.
Lawrence, after an audit concludes, a taxpayer may have the right to an appeal. What is the purpose of the IRS appeals office within the agency?
The purpose is to hopefully settle the case without the need for tax court litigation. Tax court litigation or any tax litigation is very expensive, not only for the taxpayer, but for the Internal Revenue Service itself. The Office of Chief Counsel is the litigating branch of the IRS that litigates in tax court. If a case can be settled without the need to actually have a trial and go to tax court, that is advantageous to all parties. So the Office of Appeals within the IRS is a place where a taxpayer and a revenue agent who disagree over the audit findings, it's a place where that taxpayer can go and hopefully settle the case without the need for going to tax court.
You served as an IRS appeals officer yourself. How does the appeals function differ from the examination division that conducts audits?
Well, the examination division is doing an audit and applying the law as the agent understands it, and the facts that the agent is uncovering, and comes up with conclusions. The agents normally are not attorneys, and when the case, if it goes to IRS appeals, the IRS appeals offices will normally be trained. Some may be attorneys, some may not, but they're going to be more highly trained than the average agent would be, and they're going to hopefully be able to look at the case objectively and with a second set of eyes. And if the case looks like it could be settled, then the appeals officer will try to do that, again, to avoid litigation.
At what point in the process does a taxpayer become eligible to request an appeal?
There are many, many different ways you can get to appeals. I mean, there's collection due process, which is slightly different. It doesn't result from an audit, but it normally results from collection division taking a particular position. But keeping it with respect to an IRS audit, normally when the case, the audit is complete and the revenue agent makes the findings that the revenue agent is making with respect to the audit at that time, if the taxpayer wishes to pursue an appeal, that'd be the time to do it.
Beyond the technical tax law, what factors does the appeals office consider when reviewing a case?
Well, we'll be talking, I'm sure, about hazards of litigation, but basically, the appeals officer is trying to be objective and not take any particular sides, but objectively look at the particular case, look at the issues, maybe research and find that there may be a split in the way in which tax courts have looked at that issue. I mean, there are many, many other factors that the appeals officer is going to use in trying to settle the case.
So you mentioned the hazards of litigation. How does that factor into appeals decisions?
It's very important. The appeals officer has, and it's only the appeals officer and Office of Chief Counsel that have this power. They can look at a case and say, based upon all the factors, uh, we believe the government has a, let's say, a 60% chance of winning in court and a 40% chance of losing. And then they can say, in order to settle the case, we will abate 40% of the tax. A tax court can't do that. Normally, a tax court, for example, if the issue is something capital gain or is it ordinary income, it has to be one or the other. It can't be a combination of both. An appeals officer, though, could say, I think that we have a 60% chance of winning in court and saying that this item is ordinary income and a 40% chance that we lose in its capital gain. As a result, the appeals officer can again take that hazard, reduce it to a number, and then abate in order to settle 40% of the tax. So this is a very important thing that can happen at appeals, and it's why most cases are going to be hopefully settled at appeals.
Can you walk through a general example of a case that moved from audit to appeals and explain what changed once it entered the appeals process?
Well, normally, if a case is after the audit is complete, if the IRS and the taxpayer disagree, the taxpayer can ask for an appeal. And if the case goes directly to IRS appeals under those circumstances, the problem that you can run into is the appeals officer may see things the revenue agent didn't. So the appeals officer could send the case back, for example, for further audit work. Now, the appeals officer normally, according to the manual, doesn't want to do this and shouldn't do this, but there are definitely circumstances under which it is um, uh, something that's going to happen. What I will normally do if a case is going to appeals is I'll ask for a statutory notice of deficiency to be issued. This gives the taxpayer 90 days to petition the tax court. So I'll file a petition. It costs $60, maybe an hour or two of my time to draft the petition. But what's important is that when the case then goes to appeals, and it will, after the Office of Chief Counsel answers the petition that I file in court, the case is going to go back to appeals to try to settle. But the difference is, since the statutory notice has already been issued, if now the appeals officer wants to raise a new issue, the burden of proof will be on the government rather than the taxpayer if the case proceeds to court. So it's a way that I can, hopefully by using the statutory notice of deficiency system, to prevent further examination, basically, of my client. And it also means that since the case is now docketed before the tax court, there's more pressure on the appeals officer to try to get the case settled rather than trying to send it back for further development by the revenue agent.
Are there situations where filing an appeal may not be the most strategic choice?
I think if, once again, if a taxpayer had an audit where the revenue agent may have missed some issues and the taxpayer just goes to an appeal, that could be problematic because, again, the appeals officer could send the case back for further development. So you'd want to definitely be careful. But again, this is one of the reasons why I normally ask, rather than just for an appeal, I ask for a statutory notice of deficiency, file a petition, then go to appeals, because now I've basically made it very, very difficult for the appeals officer to raise affirmative issues. And if they do, and they can, when it goes to tax court, the burden of proof now will be on the government rather than the burden of proof being on the taxpayer and me to prove the validity of the deduction or whatever the issue may be.
I'm curious, how formal is the appeals process? What should a taxpayer expect in terms of documentation, communication, and timelines?
It's going to be very, very informal. Uh, uh, Today, in fact, it's quite a bit different than it was in the days when I was an appeals officer. Normally, we would have the taxpayer or the representative come right to our office. I had an office in San Francisco with the IRS appeals. Today, a lot of things are done with appeals officers that are in other areas. I may have a case uh, that goes to appeals in Kentucky, and I'm dealing with an appeals officer in Kentucky. So I'm not going to be going to Kentucky to sit down with the appeals officer. We'll be doing it over the phone uh, normally. But regardless, appeals is relatively uh, simple and informal. It's not like when you're in tax court and there's all kinds of procedural rules that you have to uh, adhere to and that sort of thing.
As we wrap up today's episode, from your experience on both sides of the table, what tends to make an appeal more likely to resolve efficiently?
Reasonableness. If you go into an appeal and you're reasonable, hopefully the appeals officer will be reasonable and you'll come up with a settlement. But if you go into an appeal and uh, your attitude, and many representatives have that attitude, is I want everything, you're probably going to run into a problem. So to me, the most important thing is to be reasonable and, of course, respectful, but that you should be doing all the time.
Well, score one for reasonable. I like it. And that is it for today's episode of Tax Problems Explained from the Perspective of an Attorney, a CPA, and a former IRS agent, all in one. If you're facing the outcome of an audit and want to understand whether an appeal is appropriate, you can learn more at lawrenceullman.com. Thanks for listening, and be sure to like, subscribe to the show, and leave a review if you found this episode helpful. Thank you, Lawrence.
Thank you, Leanne. Have a great day.
You too.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.